Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
This is Lindsay Smith Rogers. Despite warnings from family and colleagues, the man who shot and killed 18 people in Maine last month was still able to legally own the gun he used in the spree. Today, Stephanie Desmon talks to Josh Horwitz of the Johns Hopkins Center for Gun Violence Solutions about red flag laws and protective orders and how they can prevent dangerous people from having firearms. Let's listen. Josh Horwitz, thanks so much for joining me.
Thank you for having me.
I wanted to talk to you about red flag warnings and what they are and what they can do, and really in light of this horrible shooting that took place not that long ago in Maine. What's a red flag warning?
So red flag laws, and the way I describe them, are extreme risk protection orders. Red flag is sort of the colloquial way we talk about them, but they're actually extreme risk orders. And extreme risk orders are temporary civil protection orders focused on whether the respondent is a danger to self or others. And so if there's a finding that that's in fact the case, a firearm can be removed up to 1 year. And these are laws that have been enacted in 21 states and the District of Columbia. They're done with a civil process, much like a domestic violence protective order, and they're only focused on looking at the firearm and should a firearm be removed from a potentially dangerous situation.
So how do we get to that point? How does someone come to the attention, I guess, of the court system, law enforcement? How does this happen?
Well, in all states that have extreme risk orders, law enforcement can petition to get an order heard before a judge. But in almost all states, you also have family members being able to do that. And more, you're seeing expansion into healthcare providers and some other categories as well. But almost in all states, you have law enforcement and family members, and they write out a petition. They go to a judge. It's under oath, and you get a temporary order, generally from 7 to 14 days. And what that does is allow law enforcement to ask the respondent to surrender their firearms. If they don't do that, they can then actually get a search warrant and take those firearms. 14 days later, approximately 14 days later, all the parties go to court. You have a full hearing with all due process protections. And then there's a decision made about whether the petitioner has made their case and the respondent has to have their firearms removed. And that will last somewhere generally between 6 months and 1 year. These are temporary civil protection orders.
I think I want to back up a little as to sort of understand a little bit about how we got here in needing these.
Yeah, we got here, a small team that I was part of, and with academics and practitioners, mental health providers, public health practitioners, got together really in the wake of the rising levels of suicide 10 years ago, and also the mass shootings at Sandy Hook and Tucson. And we realized that many of those shooters were legally able to purchase firearms, even though there were clear signs of risk. And at the time, when you looked at who was prohibited, you had categories that, for instance, someone who was convicted of a felony offense, someone who had been committed to a mental institute, a hospital, or for treatment. But there's many other categories of risk. And many of those, for instance, a felony conviction can take a long time to come about. And there's not a clear path, even in those cases, for firearm removal. What we realize we need to do is give law enforcement clear legal authority, which is judicially sanctioned, to go and remove a firearm when there's extremely high risk. And the reason we do that is because firearms are the most lethal means of violence. And so when you actually have a threat or escalating levels of violence, let's get the firearm out of the person's hands and then develop whatever type of treatment or help that person needs. Now, oftentimes we hear that, oh, this is just used for people with mental illness. That's actually not the case. Most people with mental illness are not going to hurt other people. What we're doing here is we're looking at expressed behavior. We're looking at people who are actively involved in violence, people who are threatening violence. We know that alcohol is an accelerator of violence. So when you see people making threats and they have a substance abuse issue. That's what we've created, a list of criteria for a judge to quickly intervene and remove a firearm before something disastrous happens. Oftentimes that disaster is harm to self, by the way. This is used a lot for suicide. It's not just for mass shootings. So I just want to make that clear. And the other piece to go back is it's not just for people with mental illness. That can be part of it. There's lots of reasons people are dangerous outside of being mentally ill. And again, I want to emphasize that most people who are mentally ill will never be violent.
Let's talk about Maine. So there are red flag laws in about half the states. Maine does not have one. What happened there?
So there's extreme risk laws, red flag laws in 21 states in the District of Columbia. And Maine considered this 3 years ago and came up with a hybrid solution. And their solution was based on, they wanted to add a mental health component. And so under Maine's law, someone has to be in custody, at least protective custody. A law enforcement asks a clinician to make an evaluation, then they go to a judge. But you can see how that's difficult. Number one, people are dangerous because of reasons other than mental illness. Number two, it prevents family members from invoking this law. But most importantly, you have to have the person in custody. You have to have a physician or a healthcare provider who's willing to make this type of evaluation. And the whole purpose, the rapidity of these things is thwarted. Additionally, you have to have the person in custody. So in the case in Maine, where they didn't have the person in custody, but they knew he was a threat, they couldn't stop him from going to purchase firearms, right? So here with a red flag law, you can remove firearms, but you can also prohibit someone from purchasing firearms. Under Maine's, what they call so-called yellow flag law, the person has to be in custody. You can't do anything if the person's in custody, and you have to, and the criteria is all about mental illness. It's very limiting and it's cumbersome. The whole purpose of these laws is to move quickly, remove a firearm, then get everybody into court to figure out what's going on, right? That's the reason. And in Maine, they didn't use that procedure, and we see the disastrous results of them not giving law enforcement clear legal authority to move quickly in these examples.
I mean, they were told from multiple places that he had a problem and they were scared and there was not the follow through. But I guess the question here is, did he fall through the cracks or is there something else at play?
Well, I think there's a couple of things that can be true at once, but I will tell you, number one is that this is actually the way the legislature designed this system. It was that you must have someone in custody. You must do this evaluation before you can go and remove firearms. And so there were multiple opportunities here. But in the end, law enforcement did not have the tools they needed to prevent the shooter from purchasing new firearms and to seize the firearms he had in his possession. Ultimately, this is a system that was designed, it functioned the way it did, and it was still a failure, okay? What I would suggest is that you give law enforcement the tools they need, because what was designed did not work. What you need to do is go back, redesign the system to create clear legal authority. That's number one, create the tools. When there's a review of all this, and I understand that the governor has just put a panel together to review this, there will be missed opportunities, absolutely missed opportunities. And at bottom under this is that law enforcement, when they needed it the most, did not have the tools they needed.
Why aren't these in place everywhere?
Well, I mean, there's been, some opposition to these, but this has been a rapidly expanding public health intervention. So in 10 years, we have in 21 states in the District of Columbia, which is unprecedented, fast pace. But some of the things that we hear, for instance, it's that it's violative of the Second Amendment, that it lacks due process. And I can address those issues if you'd like. And the first, let's start with due process, which is actually has the same due process as domestic violence protection orders. It's the same type of thing that's been found to be constitutional in courts across the country. These have been challenged in places and by and large have stood up under due process protections. And just to reiterate, law enforcement can't move under these orders without a court order. Someone has to make an affidavit under oath describing the facts, showing someone's dangerous, and very shortly thereafter, within somewhere between generally around 14 days, everybody comes back to court for a full hearing. There's lots of due process in here, and all the affidavits you have to do under oath, under penalty of perjury. These are serious items that comply easily with the due process requirements of the Constitution. The other argument, as I mentioned, was that these are violative of the Second Amendment. because, and often the argument is, well, these aren't criminal convictions, therefore you can't remove a firearm. Just last week, the Supreme Court heard a case on a very similar types of order in domestic violence protection orders. While I can't with certainty predict, it seemed pretty clear to me that the Supreme Court was poised to rule that domestic violence protection orders, which are civil protection orders, which are not criminal convictions, as long as they comply with due process, it seems to me that the court is going to rule that they do not violate the Second Amendment. And so applying that to red flag laws, I think that they will pass constitutional muster, both under the Second Amendment and under the Due Process Clause.
I was going to ask you about the domestic violence protection orders, because if anybody should not have access to a gun, it feels like it should be someone who's under one of these.
Absolutely. I mean, you just think about what domestic violence protection orders can do. They obviously prevent you from being in contact with the person who's doing the petition, but they also can separate you from your children. They can prevent you from accessing your home and your bank account. And there's also a firearm prohibition for a final protective order. I think in these circumstances, the firearm removal is a big, important piece of this, but not the only piece of these. But the firearm removal is important because you've made a finding that someone is a threat. Very much like a red flag law. A judge has found that there's a threat. In those cases, firearms are, again, the most lethal means, which is why we want them out of the equation. When there is a threat of danger, when there's been physical violence already, the last thing you want is a firearm. That escalates everything.
Well, these red flag laws sound really important to me. I feel as though they're just a tiny piece of reducing this kind of violence. And I'm wondering, is it just the best we can do right now?
So interesting. I think red flags laws are a very important tool because they are working when people are at the most risk of violence. And we know that most people, including people who at times exhibit violence, they may not be violent for their whole lives, but at a certain time, it may be a combination of relationship issues, job loss, alcohol use. They're at a high risk. And all the research we understand about violence is intervening at times of high risk is actually quite important. And that's why these red flag laws can be so effective. Now, to your bigger point, when you think about gun violence as a whole, this is a piece of a larger complex puzzle because violence and gun violence is made up of not just domestic violence, interpersonal violence, harm to self, police violence, right? All community violence, all these pieces, which is why in addition to red flag laws, we are passionate about a number of other pieces of policy and nothing more important than licensing the purchase of firearms. Firearm purchaser licensing has been shown to be highly effective in reducing interpersonal violence, reducing suicide by firearm, even reducing violence by law enforcement. So shootings by law enforcement. So firearm purchaser licensing is really the bedrock of any type of policy procedure going forward. So yes, we do need other things. We also need better safe storage laws. We need to reduce the type of, right now we have a lot of public gun carrying. That's been linked to an increase in crime in those states. So there's many other remedies, including funding violence intervention efforts. So at our center, we look at a number of different pieces, and we think together, working together is really the most effective ways to think about policy.
Josh Horwitz, thanks so much for joining me.
Thanks for having me.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, and Stephanie Desmon. Audio production by J.B. Arbogast, Holly Cardinale, Philip Porter, Spencer Greer, and Matthew Martin, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Fernandez and Shian Briscoe. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.